Okay, I think I'm live. Haven't. Okay, there we go. I know it's working now because it says live. So, good morning, everybody. I hope that you're joining me from a fun vacation. I know my most of my stuff called out today, so to enjoy the long weekend, which is nice for everybody. So, my name is Juliana Gaeta. I'm an attorney, an adoption attorney in Florida. My office is located in Boca Raton, but I travel all over the state to handle some of this adoption area where, specifically where juvenile dependency and adoption overlaps. So I wanted to hop on today to discuss some of the changes that we are seeing go into effect as of yesterday or Saturday, July 1st. And they affect the adoption statute, but this is the part of the adoption statute that has a direct overlap with juvenile dependency when there's an open juvenile dependency case for a child or the parents of the child. So it was Senate Bill 1322, and now you'll start to see it in Chapter 63.082. And I printed it out like super small because I was running out of paper. So if you see me squinting, that's why. But this is interesting stuff now because we're starting to see what I think, and I'm going to keep my personal opinion out of things. I'm really just going to talk about the bill, but I think most people know that I kind of err on the side of supporting long-term placements for children and not moving them around, certainly needlessly. And I think, and I firmly, as an adoption attorney, agree with a parent's constitutional right to make an adoption plan for their child. I do think that sometimes that has to be balanced with the best interest of the child. So I think that we're seeing that step in that direction with this new statute. So currently right now, or before right now, 63.082 is, as we said, part of the adoption statute, and it provides the directions, so to speak, when somebody has an open dependency case but wants to make an adoption placement plan for their child. So what they would do, they would have to have an adoption entity, which can be either an attorney or an agency, move to intervene into the open Chapter 39 dependency case. And in order to do that, they would have to have an approved home study, an adoption home study. It's not really supposed to just be like a placement home study conducted by DCF because there's different criteria for an adoption home study versus a placement home study. Placement home studies have different tiers, right? Different levels depending on if it's a caregiver. So it's level 1 licensing, level 2 licensing, so forth and so on. So it's supposed to be an adoption home study, and then they would intervene into the dependency case, and then from there have to show that it's in the best interest of the child in order for the child to come into the legal custody of the adoption entity and placed with the chosen prospective adoptive parents. And that person can either be chosen, typically is chosen by the parents, but it's actually up to the adoption entity to really make that placement and choose that placement. So I'm not going to get into all of these different types of surrenders and consents that a parent can sign because it's not applicable here, but that's kind of the gist of it. So that is the statute, and then there's 8 factors that the court has to consider when determining if it's in the best interest of the child to change the child's placement to the prospective adoptive parents, with the adoption entity overseeing that placement, removing that supervision from DCF and putting it into the adoption entity's supervision in order to proceed with an adoption. So I think initially this statute kind of came around, like the best case scenario, or what I think it was contemplating for, was when a newborn is born and there might have been an adoption placement plan in place before the baby was born, or shortly after, whatever, but for whatever reason DCF has gotten involved at the hospital. So this is an opportunity for mom to continue to make that adoption placement plan and kind of not be able to say, okay, DCF's involved now and we can't do a private adoption. So that's like the best case scenario, so that's where the private and public sector can overlap in order to facilitate permanency for children. So that's, I think, what it was intended to do. But over the years, what it's become is after a long-term placement, or when the writing becomes on the wall for a parent that they are potentially facing a termination of parental rights, they can make an adoption placement plan for their child, which is still a good thing because we want children to lead to permanency, but we're seeing placements come about, or these decisions to then make the adoption placement years after a dependency case has started and a child's already been in a certain home. So this bill was sponsored, I guess Senator Grail, I don't really know who she is, but she's in the Port St. Lucie area. Incidentally, I was looking her up today and I saw she also sponsored the golf cart act that just came into effect, which my kids are upset about, which means you can't drive a golf cart without a license. Not that I had my little ones driving golf carts, but they were annoyed about it. So, but this is what she's doing. So she did a lot. It seemed like we had a very busy legislative session. And I don't know if if it is busier than normal, but a lot of things came out that affect my practice areas. So that's how I've noticed it. So what's going on now, what we see with Chapter 63.082, it kind of mirrors the language in Chapter 39.022, which was what went into effect about 2 years ago in 2021, which was talking about if a foster parent or caregiver is a pre-adoptive home and they've had a child for a long time, they can, for the limited purposes in a change of placement proceeding with certain criteria, become a party to the case. And if they oppose that change of placement, they can, participate in that evidentiary hearing as a party to the case, and put forth their evidence as to why the change of placement is not in the best decision. So now we're seeing a very similar step here in 63.082. So it's kind of mirroring that language. So the first thing that it changes, so this is one of the legislative intents that got added, and it says the legislature finds that there's a compelling state interest in ensuring that a child involved in a Chapter 39 proceeding is served in a way that minimizes his or her trauma, provides safe placement, maintains continuity of bonded placements, and achieves permanency as soon as possible. So again, I think some of this is the state laws catching up to some of the science behind attachment. And a lot of times the statute uses the word bonding, but I think that the science really uses more attachments, because bond is a little bit different than attachment, but it's significant that they use the word bond. So, we'll see how that plays out, but I think attachment is really kind of the science of where children form their safe and primary secure attachments, and there's all these different types of attachments if a caregiver is not responsive to a child's needs. And I feel like I could practically get my degree in that at this point with all the research I've had to do when representing caregivers, especially in 39.522 with the change of placements. But they use the word bond, so be it. The legislator here is actually limiting the rights of parents to make an adoption placement after a certain time period. So initially when this statute was proposed, it was limiting the adoptive, the parents, the natural parents' right to make an adoption placement. As soon as a TPR was filed by the state, they wouldn't have the right to do that. This has changed since then. Now it gives them 30 days from when a TPR has been filed. I still think there might be some constitutional issues with that, so that's interesting because constitutional rights are obviously trump statutory rights, but the statute is kind of limiting that right. But constitutional rights aren't without some sort of balancing act, as I mentioned in the beginning. So we'll see. It's definitely a better version in that regard than what was originally proposed. So now, up to and including the 30th day after filing of the petition for termination of parental rights. So if a petition for termination of parental rights is filed, they have 30 days in which to determine if they're going to go forward on making a private adoption placement. and they would still have to get an entity involved. But now the most significant changes is that, here we go, and this is in section E, 63.082, subsection E, but there's numbers before that, I just can't think of them. But anyway, it says, if the child has been in his or her current placement for at least 9 continuous months, or 15 of the last 24 months, immediately preceding the filing of the motion to intervene, that's the motion that the adoption entity has to file in the 39 case, and that placement is a prospective adoptive placement, there is a rebuttable presumption that the placement is stable and that it is in the child's best interest to remain in that current stable placement. Okay, so that's the first sentence, and there's a lot to unpack there, because a prospective adoptive placement in the case law, I believe, means you have to have an adoption home study. So that doesn't mean you have a desire to adopt a child. That's nice, and it's important, and maybe you can testify that you desire to adopt a child, but for me, that would mean you would have to have an adoption home study showing that you are also an approved adoptive home. Because otherwise you're kind of a prospective adoptive home. So that's the first thing. And then you have to have had the child for 9 months, or 15 of the last 24 months. And then a rebuttable presumption. In law, that basically means that we have to take that, the judge or the fact finder is going to take that as true, that it's in the best interest for the child to stay there, and whoever is arguing against that, when in this case might be the adoption entity, or the state, whoever is arguing it, but the adoption entity is the move-in. So they would have the burden to prove otherwise, to show that it's not in the best interest of the child. So it grants, I think it switches the burden around potentially here, and that's significant. So then it goes on to say, the court shall grant party status to the current caregiver who is a prospective adoptive placement for the limited purpose of filing motions and presenting evidence pursuant to this subsection. The limited party status expires upon the issuance of a final order on the motion to intervene and change of placement of the child. Okay, so that mimics the language that was added in 39.522 regarding change of placement. And that talks about, basically, you have this limited party status. So I think what it means is probably that you don't become a party to the whole dependency case. And I'm kind of jumping ahead, but I'm assuming everyone knows that as a foster parent or a caregiver, you're a participant, not a party. There are ways to become a party in these cases. A lot of times we explore that when clients are calling us. Do we want to kind of elevate to that party status? But right off the bat, as a caregiver or foster parent, you're a participant. So, and what does participant mean? I mean, in every courtroom, it means something different. In every courtroom across the state, it literally means something different. So sometimes in Broward County, I'm able to cross-examine witnesses as a participant. And it's not just delivering a monologue. I find in Palm Beach County, it's mostly delivering a monologue of some sort at the end of everyone else talking. I'm up in Hillsborough County right now, and that judge is allowing the participants, I'm a party in that case for my client, but the judge is allowing the participants to make a closing argument and to sit in for the entirety of the proceedings so that they can then make closing argument. And closing argument would be, more than just the caregiver giving their monologue. It would be the attorney, providing argument and law for the court to consider. So, it means something different in every courtroom, and the needle's always moving, and we're always, trying to push that. But what this statute does is takes that out anyway and just says you're a party. And what can a party do? In my opinion, and I've been fighting some cases with DCF about that, but so far successfully, the courts have ruled that as a party, you can conduct discovery, which means taking depositions, requests, for documents, and then presenting your evidence in court for that evidentiary hearing. So that's the difference. But as I said, I think, so, if you haven't gone to law school, it's probably going to be hard to conduct an evidentiary hearing without knowing the rules of evidence. So that, you know, not everyone's going to be in the position to hire an attorney to rebut this, or to oppose this is what I mean. But that's probably if you feel that the child has been in your home, you feel it's not in the best interest of the child, and your position is that you would want to oppose a change of placement pursuant to a private adoption plan, that's how you're going to be able to do that. You're going to be able to come a party and put on evidence to rebut it or to oppose it. Because, and I'm saying oppose and using rebut interchangeably, but I'm catching myself because we don't want to, because a rebuttable presumption in the law actually does mean something, and there is a rebuttable presumption. So the burden is on the moving party to show that it's not in the best interest of the child to move, or that it is in the best interest. So to rebut the presumption, this is language in the statute, to rebut the presumption established in this paragraph, the intervening party, that's the adoption entity, must prove by clear and convincing evidence that it is in the best interest of the child to disrupt the current stable prospective adoptive placement using the factors set forth in paragraph F and any other factors that the court deems relevant. So the burden of proof is clear and convincing evidence. That's what that means. And then it kind of goes into the factors. So the factors have always been there, but now they kind of have changed the factors a little bit. So we'll get into that. And there were 7 or 8 factors. I think there's 7 now. I think there were 8 before. But we're talking, there is also kind of a catch-all factor that's always been there, which is what's best for the child. So kind of like, you know, there's factors that talk about the permanency offered by both the child's current placement and the prospective adoptive placement. And that's why I think it's imperative that if you're opposing this, you would have to have a private adoption home study. The established bonds, it's the word bond again and not attachment, but between the child and the current caregiver with whom the child is residing, if that placement is a prospective adoptive placement. So it just added the word with whom, it added the sentence with whom the child is residing if that placement is a prospective adoptive placement. I don't really know why. Okay. The stability of the prospective adoptive placement in which the child has been residing, which must be presumed stable if the placement meets the requirements of paragraph E. And E was what I read about the 9 months. The stability, the importance of maintaining sibling relationships, if possible, the reasonable preference and wishes of the child, and whether a petition for termination of parental rights has been filed pursuant to, and then it gives parts of the statute. So those are the parts of the statute it cites, I think, are like the sexual abuse parts of the statute for termination or egregious conduct. So you have to take into account, I guess, what the grounds are for the termination of parental rights. So sometimes that's applicable, sometimes it's not. And then again, number 7 is kind of overall what's in the best interest of the child. So I think this took out, if I'm remembering correctly, because I printed this on my printer and I think it's leaving out some of the colors. But what I remember from the old statute was also the wishes of the parents, or what the parents desire to do with private adoption placement. So they took that out. So then, if after consideration of all relevant factors, including those set forth in paragraph F, the court determines that the home study is adequate and provides the information to make a determination that the prospective adoptive parents are properly qualified to adopt the child and the change of placements in the best interest of the child, the court must order the change of placement to the prospective adoptive placement selected by the parent or adoption entity under the supervision of the adoption entity. So after looking at the factors and reviewing the home study, if the court finds it's in the best interest, then they will move the placement to whoever the prospective adoptive parent is chosen, either by the parents or the adoption entity, and the adoption entity will then supervise that placement pending the finalization of the adoption. This does add a transition plan. So it says the court will, the order must allow for a reasonable period of time to transition. So not just pulling the child out of the home. A lot of times though, prior to that, the child may already be having visits with the prospective adoptive parent. So I think it still means the court could find that a transition's already been taking place, and then, a further transition is not necessary, but, It does talk about how the transition plan should be developed to minimize trauma of removal of children from their current placements. And, you know, I think that probably if you read that with the multidisciplinary team meeting statutes, it would be, I think, makes sense for, you know, all the people and professionals involved to kind of come together to make that transition plan. So actually it does say that. So it says developed by the department in consultation with the current caregivers, prospective adoptive parents, and the guardian ad litem if one is appointed. So it's kind of everyone coming together to say what would be a good transition for this child. But obviously that's hard to do if one person opposed it, other people joined it, but then everyone has to be grown-ups and put that aside, and you know, the court's made an order, and let's figure out how to do this in a way that will minimize disruptions and trauma for the child if the court ordered the child to move. So I know I see some comments. I'm going to read them. I know Katie, you know, what's a step in the right direction. These things, the wheels of justice move very slowly, and you know, it takes time for the laws to sometimes catch up with the science. So I do think, as I stated, this is an attempt of the laws to kind of catch up with that science and to put some checks and balances on unfeathered rights, because we do have to balance the best. I mean, parents have constitutional rights to their children. We all agree that's a good thing. Absolutely. But there is a little bit of a balancing act, best interest of the child, and I think that's what we're seeing. So the adoption entity has to provide the report until it's finished, the adoption, and the adoption entity is responsible for keeping the dependency court informed. So that's kind of extra stuff that's not really important to anyone but the adoption entity and the court. So, and then it talks about how they can go on to how they file the adoption petition. And yes, so that is, then there's another section that talks about like the financial stuff. So if the department has to do some providing accountings to the Office of Program Policy Analysis and Government Accountability, a list of all child caring agencies registered. So that's not entities, that's not attorneys, that's agencies, but they're going to talk about, they're going to go through and see what is the financial, I guess, incentive of maybe doing these adoption interventions. I don't know what they're doing with that. I haven't read it all the way through, but it's interesting. So, okay, the question is, if a child has been in the same foster home for 3 to 6 years, but parents are still working case plan, it's a long time, so no TPR, how do you change best interest of being reunified? Well, I think you mean, how do you change the goal to maybe adoption and not being reunified? I mean, it's not, the court is always looking as to what's in the best interest, and then separate from that are the goals of the case. So the goal is either reunification, strengthen and maintain, adoption, and sometimes we have concurrent goals. So there are a few things. I mean, you as foster parents should be going to judicial reviews. 72 hours before judicial review, you're supposed to get a judicial review report. If you don't, I would insist upon it, and I would go to court and ask that we have a continuance until you got the report, because that tells you a lot of things. There should also be multidisciplinary team meetings going on and staffings where you can come and kind of give your opinion as to what the goal is, but the court has a lot of leeway during a JR to change the goal. And foster parents, I think, besides this 39.522 change of placement and now the 63.082, foster parents have the most rights at a judicial review because the court wants to hear from the caregiver. So that's where I would be vocal about what's going on and requesting the court consider a change of goal to adoption, or a concurrent goal at least. 3 to 6 years is a very long time. That's maybe not unusual, but 6 years seems a little high. I mean, I've done a few that were like 5 years, but the other option is, I've talked about it before, anybody has the right to file a termination of parental rights petition. I always say it's like, that's like a nuclear option, so you don't just come off the bat doing that. There's a lot of thought that goes into that before that's something that's done, but that's another option. I don't think that means the court has to then change the goal. I've heard a judge recently believe that that's the case, and I don't think that's true. And that would have been good for my clients, but I still informed the court that I didn't think that's what the law required, that we could still go forward on our termination of parental rights petition, and the goal could be whatever the court decided the goal was to be. Didn't mean that she had to change it to adoption. So at that point, the judge decided to do a concurrent goal, so it's still reunification concurrent with adoption, and then we're moving forward on our TPR petition in that case. So I'm, for those who know, I work very closely with my partner, Alan Michelle, who's kind of a legend in this arena. And he has what I call his manifesto. It's a loving term. It's a compilation of kind of all the rights that foster parents have, and it's very comprehensive. So I think sometimes it's a lot of information, and if you're not in this particular field, it might be like a lot to take in, but it's very comprehensive. I'm sure he's going to be updating it for the new laws that have just come into effect on Saturday. And so if anyone wants a copy of that, I'm sure he'd be happy to hand that out, or to provide that to you, so you can just message me when that's updated. We'll get that out. It's very, very, very good about discussing all the different things that we kind of discussed here today: participant, party, filing your own termination of parental rights, and most importantly, being informed at those JRs. I think that's probably the biggest thing. So if there's any questions, you guys can always email me. So this is interesting. I know a lot of the adoption attorneys are not super happy about it. It certainly places a lot more limits than there were before. It'll be interesting to see how it plays out. I'm not against the private and public sector coming together to create permanency for children. I do think that there is space for that. And that can be a really good thing. I just did one recently where mom gave birth. Oh, we have a co-host. Oh, you on my phone? Okay. Here's my co-host today. Some camps are open, some aren't. So what was I saying? Oh, I did one recently where, mom was always intended to do an adoption plan, but then, she was an addict. She left the hospital early. And the hospital called the department, DCF, of course, because there's nobody there for the child anymore. And then DCF got involved, and they sheltered the child. They filed a TPR right away. So under the original statute as it was proposed, if they had done that, mom wouldn't have been able to make an adoption plan for the child once she got back in touch with the entity to make that adoption plan. So that's why I think this at least gives them 30 days to do that. But that's kind of what I think the statute was intended for. So she picked her adoptive parents. DCF had already kind of got involved because the hospital, it's like a train that leaves the station. But we were able to then go to court, intervene, place the child with, from the foster home that the child was in for a short time with the prospective adoptive parents that birth mom had chosen. And to me, that's how it's intended to work. And that's a great thing when that happens. So, so I do think there's space for that. All right, let's see. Does a prospective adoptive parent need their own attorney, or can they rely on the adoption agency for representation? Okay, so that's interesting. So the prospective adoptive parent, sometimes it's not cost effective for everyone to have their own attorney, right? I certainly think in adoptions, I'm belt and suspenders when it comes to practicing adoption. So for me, when I act as a private adoption entity, I'm happy to have everyone have their own attorney if everyone can afford that, because the adoption entity represents the adoption entity, and the goal of the prospective adoptive parent and the adoption entity are aligned until maybe they're not. So, and I don't know when that might be, or if that would ever happen, but it could happen. So that, yes, you don't need to have your own attorney, because the agency that is moving to intervene and to have the place be with you, if that's who you are, then you have the same goal. But that's going to depend on what the consent says. If the consent is a conditional surrender directly to the adoption entity, and the adoption entity has the right to choose whoever's going to be the prospective adoptive placement, then you might want to have an attorney present or on standby, or to look that over. If it's an identified consent directly to you, then your interests are probably more aligned than not. So that's kind of a complicated question. But for the most part, your goals are probably aligned. But certainly if you can afford an attorney, at least you probably don't need the attorney to go to every single hearing, but maybe to look over documents and things like that. I would recommend it. Okay, in our case, TPR petition has been done and we have advisory hearing coming up. The goal has been changed to adoption by a parent's MIA. When is the right time to hire an attorney? Well, I'm an attorney. So my answer is going to be you should hire an attorney all the time right away. But that's not always, I know, again, that's not always cost effective. So you can always do a private adoption. The second part of this is we want to move forward quickly. How can you get the home study moving forward? They're moving slowly to assign an adoption case manager. Can an attorney help with this? So, I don't think they would do a home study until the child's actually been terminated, because technically the child's not available for adoption. But you can always do your own private adoption home study. There's lots of people that do that work, and I work with them, social workers. I work with a lot of them. So sometimes we have them do a private home study, and DCF will usually accept that as long as it conforms with the statutory items that are needed to do a home study. So you can get that ball rolling on that if you wanted to ahead of time, but probably you don't really have to. Sometimes what we do, Alan and I both have clients who come to us and they just kind of put us on retainer so they can ask questions. We can kind of monitor things. We're not necessarily filing notices of appearance or doing all, everything that we do is strategic and calculated and well thought out. So it's not like come to us, file notice of appearance, and this is what we're doing. We have to look at everything, decide how we're going to proceed, but they kind of keep us on retainer to be able to kind of know that. Certainly if you've had the child for, birth to 7 months is not as long as the statute talks about 9 months, but certainly if you hear about them trying to change the child to a placement with a sibling, an afterborn sibling, or whatever it is, we see that a lot up in Hillsborough County. I know some of those Marion counties up there, but that would be a good time to consult an attorney, but probably it's going in the direction that you want it to go in. Just it's going to move slowly. Because that's the nature of this work. So, but yeah. So, I don't see any other questions coming in. I have one. I asked if I could pay for a probate home study, and private home study, and the case manager said they wouldn't accept it. Yeah, I know. I've heard them say that, but it's not true. A home study is a home study. So, I've heard them we get private home studies and they say, well, we still need to do our own. And if there's no reason to not let them do their own because now it's at that point and they're ready to do it, then we just let them do it. But they can't say they can't accept a private home study. That's not really how it works. If it's statutory compliant with what needs to be an adoption home study, then it's an adoption home study and they certainly can use it. So I think that sometimes depends on the CBC. But we would want to explore to see if they'll accept it, and probably consult with an attorney before you spend like $1,500 to $2,000 on a private home study that's not going to be used. So, all right. So if there's no other questions, it's a lot of information thrown at you, to be determined how this all plays out in court. But if you have any questions, you know where to reach me, and also. If you're interested in getting kind of the Allen Manifesto, as I call it, reach out and we'll get you get your email and get that sent out to you when it's updated. So take care. Enjoy the holiday weekend, everybody. Bye.